A woman calls 911 and tells police that her husband has been attacked by an intruder. When police arrive, they find Dale Harrell clinging to life, multiple skull fractures, and his wife covered in blood. Her name was Marissa Devault, and nothing about her changing story would hold up. What happened next was a shocking murder trial full of compromised witnesses, ever-changing stories, and a cover-up that would expose cheating, allegations of abuse, and a story that would remind everybody of a case that had happened 1 year earlier in that same courtroom, Jodi Arias. Welcome to Courtroom Autopsy, where criminal trial attorneys dissect the most infamous trials. I'm Ryan McPhee. This is my law partner, David Lish. Today we're going to break down the evidence that exposed Marissa Devault in her trial and uncovered a secret love triangle turned insurance scheme. Let's start the autopsy.
All right, so Marissa Devault, it's spelled D-E-V-A-U-L-T.
Yeah, a lot of people think Marissa Devault,
right?
But it's pronounced Devault.
Devault. So this is an offense, a crime that took place back in January of 2009. Devault was living with her husband, Dale Harrell, in the East Valley. I think it was in Gilbert, in Arizona. She had 3 kids, 2 of them with Dale, one a child from a previous relationship. I'll call them an average couple, right? She worked, he worked, and the 2 of them, were seemingly doing okay. They did rent a home out in Gilbert, and they had another guy living with them. This guy's name was Stan Cook. He apparently was there as we'll call him a roommate. This fellow had been in a car accident previously, had some memory problems. But this was the living situation back in January of 2009. And then on January 14th, 2009, 911 call goes out. It's Marissa on the phone. She's calling, claiming that she didn't give a lot of details. Something had happened, and she needed police assistance. Police show up. There is Dale, kind of hunched over on the bed, falling onto the ground, blood everywhere. And Marissa says what?
Well, first, she says somebody broke in, an intruder, and attacked him with a hammer, right? And I believe the hammer was there, still on the scene. That's one of the big things about the case is quickly that story changes and evolves over time. Also, the case kind of changes, right? Mm-hmm. Because initially she's charged, she's not a suspect. Not charged. Right.
She says, hey, these guys or somebody had broken in, they had, hurt Dale, and, it was all I could do to, not die or not get hurt. As the investigation proceeds forward, then she does become a suspect. She does get arrested, and she makes statements about now she's the one who hit him over the head with the hammer. At the time he hadn't yet died, but causing very, very serious injury, skull fractures, because he was abusing her. He had sexually abused her. And so it was all she could do to defend herself.
And it appeared there was actually an intermediate story, too, where she said that the roommate had attacked Dale, or Stan. That came after Stan. It was a little confusing on when that story came out. Right. And again, he was a convenient person to blame because he actually couldn't deny it because he has no short-term memory. He would just basically say, oh, okay, I don't know. I don't remember doing that.
He wasn't able to provide any corroborating details. And so Devault is arrested, charged with aggravated assault, taken to court, the initial appearance court where she's given a bond. She did bond out.
Right.
And then that next night, she is apparently attacked. She goes out on a run, and
I think it's a little bit later because this is a weird part of the story. Mm-hmm. It's maybe 9 days later or 10 days later that Dale succumbs to his injuries and he dies. And the next morning or that night, she's attacked while out on a jog. It seems
by an unknown assailant,
coincidental,
broken jaw and ankle, and then that they're looking into this guy, Stanley Cook. Anyway, the facts are very unclear about what's going on.
And they changed that charge to a murder charge.
Well, that's because Dale now has passed away.
He passed away.
And then, Devault is now charged with first-degree murder.
Yeah, and that's an interesting piece. We like to talk about kind of the legal parts of this and why. Some people might ask, why would she be released right after the situation when they suspect her of a hammer attack on her husband that was so severe? And, we can talk through that a little bit of how that happens, at least in Maricopa County. This is where we practice, both as as prosecutors, now as defense attorneys.
So what happens is, police can arrest somebody, they'll book them into the jail. And if they're booked into the jail, then they have a right to be seen by a judge within 24 hours. And so in Maricopa County, there's this constantly running, they call it the initial appearance court. So about every 3 hours, a judge will see a group of people, and the judge has to determine two things at that initial appearance. One, whether there's probable cause to hold the person, and then two, whether there's any release conditions that need to be imposed to ensure the safety of the public and to prevent the defendant from committing any additional crimes.
Or from flight.
Or from flight. Yeah. And so courts during that initial appearance, if they find that there's probable cause, then they'll impose a bond or they'll impose release conditions. That can be as low as your own recognizance, meaning you go and come back on your next court date, all the way up to non-bondable in certain cases where they're not allowed out. In other cases, aggravated assault, as this was at the time, I don't know what the bond was, but I can expect that it was, an expensive bond. We'll say $50,000 or $100,000 or whatever it was.
Yeah.
And so if that bond is paid, then the person is released and allowed to, be in public, sometimes under conditions. Maybe they'll have an ankle monitor, maybe they're on house arrest or something. But a person can be let out. Now, once the charges are elevated later by a grand jury through an indictment after Harrell passes away, murder charges, the bond and the release conditions are going to go way up.
Astronomical.
And then at that point, Marissa was held in custody in the jail.
And even those, it's kind of interesting, right? Is somebody has a right to a bond unless you can prove and show otherwise under very specific circumstances.
That's right.
And so the court imposes these $1 million or $2 million bonds that very few people can afford.
Right. So the bottom line here is Harrell is dead. Marissa is now charged with first-degree murder. She gave a number of sort of different stories to police. Initially that somebody else had done it, later that she had done it, then claiming self-defense. Now she's held in custody and awaiting trial. And her case then develops over these next several years. She doesn't go to trial until 2014, January of 2014. So 5 years after the murder, which isn't unheard of. Many times homicide cases can take a while to get to trial.
I think there was where she was supposed to go. She had it ready to go. I think like in 2011, something happened, and there was a delay. And this is kind of overlapping, like we talked about with the Jodi Arias case. Yeah. And so Jodi Arias goes to trial the year prior to her, and that murder also occurred about a year prior to this one.
Yeah, right around the same time. So what then comes out as this investigation continues to develop is, Stan Cook is initially a suspect, not anymore a suspect. He's ruled out.
Apparently,
physical evidence keeps him from being a suspect. Plus his story or lack of story just doesn't hold up.
Yeah.
And pretty clearly, the evidence points to Marissa, especially given her statement saying, I did it, okay?
Yeah,
and now claiming self-defense.
Yeah, and then they dug into some other things that appeared to give her motive, give her reason to do that, and that's what, the prosecution put out in trial, and we'll talk a little bit about that. But, one of the big ones was it was found, so there's not a lot of information about Dale himself as the victim in the case, but it's clear that they had met earlier in life in Lake Havasu area in Arizona, and if anybody's familiar with that. But that's outside the valley. It's outside Phoenix and things like that. It's 2 or 3 hours away. And then they had moved to Phoenix, not together, I don't think, and then they had gotten married and moved to Gilbert. She had, as far as her past, she had been an exotic dancer at one point, but she had a child and then got together with Dale, and then he was raising that child, and they had a couple of children of theirs.
Yeah, and so seemingly a good relationship. However, as the investigation and the case develops, we learn that Marissa was involved with a guy, kind of a sugar daddy type fellow.
In fact, titled Sugar Daddy, where he found her on a website called Sugar Daddy. And apparently, we're talking to people here in the office, that's what they remember, right? That this was a trial about a guy, that was kind of the salacious detail here, that she had a boyfriend from the Sugar Daddy website.
So his name was Alan Flores, an older gentleman, had some money. And one of the things that, was an important part of this case was the idea that Marissa had borrowed about $300,000 from this guy, Flores. And she had supposedly made some statements to him about the need to get rid of Dale either herself or through a hitman or some other way. And this guy, Flores, he apparently was a diligent note taker, decided to, jot those things down in his computer.
He was studious.
He take notes.
Apparently was Yale or Harvard educated. Yeah. So that was an interesting piece, and we'll talk about that, how that came up later on, as far as Devault claiming she didn't get a fair trial, partially because of that evidence that came in.
Yeah, so, you have then this kind of a love triangle. She's seeing Alan Flores, behind the scenes, and then has this massive debt that she's got to repay, supposedly. And so that's where the prosecution gets their motive, because apparently Dale had a $1 million+ life insurance policy, and Marissa Devault has to somehow repay this Allen fellow, and that becomes the motive for the murder. That's why she apparently committed this offense. In fact, in the prosecutor's opening statement, one of the comments that the prosecutor says was, Marissa likes easy money. And so for them, the theme of this case was easy money. Marissa's just there to, collect on the life insurance.
Yeah, and like we've alluded to, the entire time this trial, it was a year after the Jodi Arias trial, which captivated the attention of the entire country. Mm-hmm. Everybody was comparing this case to it, as far as her as the defendant. She was this younger, attractive person who now is in trial with glasses and a cardigan sweater. It was very, very similar kind of situation, where, it was a very violent death. There were a lot of similarities. What else can you think of? They were both very close together as far as geographically. You got Mesa and Gilbert, which were just a few miles away.
2009. Yeah. I'm going to call this sort of Jodi light, though.
Isn't that what somebody called it?
It's like a twisted case of deja vu. Tonight in Arizona, in the very setting where the famous Jodi Arias murder trial unfolded, a jury is now mulling the case of another young woman with eerily similar circumstances.
So how many times do you think you had it?
That's 36-year-old Marissa Devault, mother of 3. She is accused of killing her husband, Dale Harrell, with a hammer as he slept in January of 2009. She pleaded not guilty, claiming self-defense, snapping after years of physical and sexual abuse from her husband. It is almost the same defense claimed by Jodi Arias, convicted last year for stabbing, shooting, and slashing her longtime lover, Travis Alexander.
The simple answer is that he attacked me, and I defended myself. He called me a bitch, and he kicked me in the ribs, and got on top of me and started choking me.
What are the key similarities between this trial and the Jodi Arias trial?
They are both charged with capital murder, and they both claim that they were abused by their husband, boyfriend, by their lovers.
In both cases, the prosecution painting each defendant as a cold, calculating killer, starting with the interrogation tapes. Devault, hours after the killing, is seen laughing awkwardly, describing the events of the night.
I saw a hammer go into Dale's head.
Her strange behavior, not far off from Jodi Arias' conversations with herself.
Should have at least done your makeup, Jodi, gosh.
And handstands. And the blame game. Devault originally told police she saw her roommate, Stanley Cook, murder her husband, only to change her story to self-defense.
So Stan didn't have, and Stan was in it.
No.
Arias had 3 stories. First, she wasn't there.
I was nowhere near Mesa. I wasn't even close to him.
Then, masked robbers killed her lover.
There were 2 people there. One was a guy and one was a girl.
What did they say?
Yeah, the girl wanted to kill me too.
Before eventually asserting self-defense.
Which story do you want to believe?
And even that defense bears similarity between the 2 cases. Both women claim that they were victims of a pattern of abuse, a claim known as battered women syndrome. But while Devault had a witness to the alleged abuse, her teenage daughter, Arias had no corroborating witnesses.
For me,
Yeah.
it's almost like a sort of a copycat, not the crime itself, but the idea that, she could be the next Jodi or something like that. I think Jodi Arias was very unique. It was a media circus like we had talked about. Certainly, this case, Marissa Devault's case, has similarities to it, but
Even the defense, I think that's another real striking
the defense,
one.
I think, is a
was
good one.
very similar, right? Where she's saying, at least first of all, that they both changed their stories multiple
Right.
times. Then they both settle on the defense of, I was a victim of long-term abuse by this person. I'm a battered woman syndrome, right? And they have an expert come testify in trial about how sometimes they do this as a preemptive strike because they think that they're in danger.
It's the
It
only
was a
way out.
Very similar defense itself, which again was alluded to in some of the materials we looked at, that her and Jodi were in contact. They likely would have been in the same jail.
they would have been at the Estrella jail in Maricopa County. Now, whether
Awaiting trial.
Yeah, whether we know that they had any specific contact, I don't know.
There's
But
some
certainly
allusion to that,
there's
yeah.
a possibility that they could have, had some form of contact.
And I don't think a prosecutor was able to, opine that in trial and say, hey, look, that's how she came up with this. Just a year ago, her buddy came up with the same, same
Right.
defense or whatever. But.
Well, and I think, certainly it is a valid defense. It didn't work in this case. It didn't work in the Arias case. I mean, spoiler alert, Marissa Devault is convicted, and that's why we're talking about her case, is because of, how it played out in court. But she puts on this defense. I think that type of defense could have legs under the right circumstances. The problem here in this case, is that it's a very, violent, bloody attack that doesn't show any, and there's no proof that Dale was doing the things or did the things that she accused him of doing. In fact, she writes this long, confession statement saying, I did this because of all of these things that Dale did to me, and yet the investigation reveals that there's nothing to prove that he had actually done those things to her. Not that they're not true,
Right.
but that there wasn't anything to support it.
Yeah, and that hurts her case, right? I mean, whether or not it's true, when you put that in front of a jury, if there's nothing to corroborate that it happened, it's hard for them to say, okay, I can really grab onto that and say, yes, it happened. I do believe their oldest one at the time of the trial was 18 years old, who did say something about some abuse. Other than that, they had multiple family and friends and anybody they could find, because she also, I think, made the mistake maybe in that confession of saying there were witnesses there who saw him, I don't know, she actually said, push me around and dislocate my shoulder, and one of the witnesses had to pop my shoulder back into
Right.
place. And they go talk to these people who are like, didn't happen.
I didn't see that.
Yeah.
must
So, and the other part we talked about that really hurts this type of case is when you change the story, right? And certainly there's reasons for people to lie initially if they're worried that they're going to be implicated in a murder, even if they know they played a part and that nobody's going to believe them or whatever, so they come up with another story. But it makes it hard as the defense to say, here's what happened, when they gave a couple of other stories first.
Yeah, it just makes any of your stories not believable, not credible, because of their changing nature. So trial takes place, as we said, in January of 2014. It's presided over by Judge Roland Steinley, a longtime jurist in Maricopa County. I tried my very first trial in front of Judge Steinley. He's got a good sense of humor, but he's also a very serious and intimidating judge. I remember my first trial as a prosecutor. It was a drug possession case, and I was terrified of Judge Steinley. And he's the type of judge who has a very intimidating presence. We talked a little bit about the Arias case and Judge Stevens. Judge Stevens, great judge, smart woman, and certainly she controlled the courtroom in Arias. But I think the prosecution was able to run away with some things, of course, in Arias that I don't think they could have gotten away with in front of Steinle. Steinle held a very tight line and does as a judge.
Yeah, and we'll compare one of the big differences here. Both her and Arias make allegations of, prosecutorial misconduct. Different prosecutors.
Here, judicial misconduct.
Right. Different prosecutors, but you can see how by the way it was run and reined in, that those arguments just really didn't have the legs in this case that they had, in the Jodi Arias case.
And so Judge Steinle is the judge. Michelle Arino and Eric Basta are the two prosecutors from the Maricopa County Attorney's Office. The defense team is Alan Tavasoli and Andrew Clemency. And those are four lawyers that have been around for a long time. When I was a prosecutor at Maricopa County, I had worked with Michelle. I didn't know Eric Basta that much. I've seen him around, but I've rubbed shoulders with and worked with Michelle. Also, on the defense side, I worked with Andrew Clemency years ago. We were in the same firm for a little bit of time. And so these are, lawyers that we see, faces that we see in the Superior Court. The trial, Arias, of course, lasted for months and months and months.
67 days, I believe.
This trial was only 16 days.
Yeah, I thought it was interesting. The whole trial was 16 days. Mm-hmm. Jodi Arias was on the stand for 18 days.
She testified for longer than this case it lasted.
Yeah.
But, there's similarities, of course, but major differences. And so Duvois goes to trial. One of the issues that she raised at trial or prior to trial that was later examined on the appeal was, a Miranda warning situation. Now, we talked about the OG Miranda case, right?
The Miranda case.
Miranda versus Arizona.
Yeah.
And we learned a lot. We learned that in order for Miranda protection to apply, there have to be two things. You have to have custody, and there has to be police interrogation.
And just a quick recap of if you don't know what Miranda is. So it's basically somebody saying, the statements I made to you, police, are not, you can't use them in trial because those statements were made in violation of the rules that were established by the Miranda case.
Which are, police have to read you your Miranda warnings when you're in custody and subject to questioning. If they fail to do that, any statements that you make then are not allowed to be used in evidence. And so what happened here was that Duvois had made some statements when she was at the police department. Now, the argument was that she was in custody. The problem with that argument was that she went to that police station voluntarily. She was told that she was free to leave. She was not placed in handcuffs. She was, accompanied by a detective during the course of that interrogation. And that interrogation lasted for 5 hours. But she wasn't deprived of food and water or anything like that. And so she makes this argument, anything I said to the police at that time should be thrown out because I was effectively in police custody. Court of Appeals disagrees.
Yeah, and that's really the analysis that every court's going to do when you claim that it was in violation of Miranda, right? First, they're going to look at were you in police custody? Were you detained in any way? But really, I think the way they break it down is to say, would an average person think that they were free to leave? Right?
Yeah, the rule is, would a reasonable person in her position understood that she was not in police custody or that she was free to leave. And so what the court does is they look at what they call the totality of the circumstances, all of the facts surrounding this situation. And because, she really wasn't held or detained and she was free to go and she had come there on her own, they say no custody.
Bills and money management. That's what our arguments are always about. It's like, God, just, do we have electricity? Do we have water? Do we have food? Do we have a roof overhead? Shut up.
The 36-year-old Gilbert woman claimed she was a victim of abuse and didn't see another way out. But the prosecution is telling a different story, saying she killed her husband for an insurance payout. At times during the interrogation, Duvois was cheerful and talked about Dale like a high school crush.
I sent some text messages, I love you, hope you have a good day at work.
Mere minutes later, she recounted what she claims was non-stop abuse.
He actually pinned me down on the couch and hit me. That pisses me off. I've been here long enough, I should know. I should know what his indicators are.
There's still a lot more of this interrogation that jurors haven't seen, including answers from Devault herself explaining what exactly led up to that brutal beating. Steve?
Yeah, certainly doesn't seem like a woman who's been through such a trauma there. We'll continue to watch it. Thank you, Stephanie.
And they had argued, the police, that they didn't know they didn't see her as a suspect at that time, right? That they saw that she was
Not
the victim.
initially,
Yeah.
and then later, yes,
Yes.
after she starts talking. And that's why she wants those statements to be tossed because, as you said at the outset of our program here, the more statements that you have, the more difficult it is to mount a defense. Here, if you can exclude some of those statements because of the Miranda violation, well, then my defense gets a little bit easier. There's less that I have to explain away by way of inconsistencies.
Less contradictions.
Right.
And that's just human nature, right? But especially in a case where they've changed the story.
That's the biggest
clearly
thing.
changed the story. But we've even seen cases where you're not changing the story, but the police can, or the prosecutor can take just little snippets, right, out of 3 different statements that make it look like you were contradicting yourself. Which again, is always why we tell people, exercise your right to remain silent.
Yeah, I go back to that thing, keep your mouth shut, right? Don't say anything. So that issue gets resolved not in Duvois' favor. The Court of Appeals says, no, those statements can come in. They then move to this issue regarding Alan Flores and his contemporaneous taking of notes. I mean, she apparently, as we had said, had told him, hey, I need to either hire a hitman or I need to get rid of Dale. And, Mr. Flores, as studious as he is, Mr. Harvard, whatever, types them on his computer. And I don't know. I don't do that.
And I don't know if he said to the police, I've typed it into my computer, because otherwise, how would they have gotten access to his computer? Because that's what happens. They seize his computer. And that must be what gave them that right to do that, because they seize that, and that puts him in some real trouble.
Yeah, so before we get to that part, let's just run down what happened with those statements. Basically, Duvois says, those statements themselves should not be introduced. The typed statements should not be introduced in evidence.
The statements where he's saying she admitted to him that she needed to have Dale taken care of or killed for whatever reason.
So the way Judge Steinle resolves that is he says, okay, Flores can testify to those things that he says that Marissa told him. But we can't introduce, the state can't introduce into evidence those contemporaneous notes that he took. Why? Because they're hearsay. They are a prior consistent statement that has no exception under the hearsay rules.
Yeah,
and there's a little bit of a tussle legally over how the state could or tried to introduce those. At the end of the day, they don't come in. Steinle keeps them out.
So that was a smart move on his part, as far as kind of
Steinle,
taking the precaution of saying, look, any witness can testify to what they observed. Hearsay says you can't use an out-of-court statement, but except for the defendant. So when the defendant says something,
that's a non-hearsay statement.
It's actually not hearsay.
So, again, this is sort of I'm going to call it a boring legal issue. It's sort of the judge dissecting and the Court of Appeals dissecting hearsay. But you alluded to something that I think is fascinating in this case. Police get a hold of Flores' computer. And what do they find on his computer in a search warrant?
Bad stuff.
Bad stuff. They find child pornography on his computer. Now, for those of you who don't know, in Arizona, child pornography is punished severely. A single image or video file can land you a minimum sentence of 10 years in prison, a maximum sentence of 24 years in prison.
Per image.
Per image.
Stacked.
Flat time stacked. So if you have 10 images, your minimum sentence is 100 years. Now, I don't know, and it doesn't say the quantity of images that Flores has on his computer, but it's enough to get people's attention. And so what do? You've got this key witness now in Duvois' trial who's got some really important things to say about her motive and her intent, and yet this same guy has awful material in his computer. So what does the state do?
And subject to prosecution for that.
Subject to
You've
prosecution.
got two criminals with really serious, terrible crimes, right? And you have to make a decision as the prosecutor. And they had to decide and say, can we just prosecute these people separately and say, we're just not going to use Flores because he's not a credible witness at that point, potentially, or he's not going to be willing to testify if he's in the midst of being prosecuted, or do you give him a deal? And do you say, tell you what, if you testify for us, you're not going to prison for 100 years or however long, and I don't know how many.
Yeah, so they do an immunity deal. They say, okay, Mr. Flores, you're not going to be subject to prosecution for this offense of possession of child pornography. Now they call it sexual exploitation of children. But he's not prosecuted for that, and he has to execute a testimonial agreement, a contract that says, in the Marissa Devault trial, I agree to testify truthfully. And if the prosecutor discovers, or it turns out that he doesn't testify truthfully, then he's in violation of that agreement and could be subjected to perjury charges or something else. But what an interesting situation. The prosecution has to decide which is the more serious case that we want to prosecute. Do we want to prosecute the murder, or do we want to prosecute the guy who's got images on his computer?
Yeah, and there's really other really interesting things about how to handle that as a defense attorney and as a prosecutor, right? Obviously, that's going to be fertile ground for a defense attorney to say, you can't believe a word this guy says. He's just saying whatever he has to say to keep himself out of prison, right? So he is motivated to tell the prosecutor or tell you as a jury whatever the prosecutor tells him to say, right?
Yeah, if I'm the defense lawyer cross-examining Flores, I am carving him up, right?
Yep.
I mean, it starts with, Mr. Flores, you had child pornography on your computer, didn't you? Yeah. And then you take it from there, and he's got to say yes. Now, certainly that weighed into his credibility, and I know the defense, of course they did. They cross-examined him in depth on that agreement, and the jury has to decide, do you believe him or do you not believe him?
Yeah, and I think some of this we have to kind of speculate on as far as what happened in trial, but it appeared to me that the state, they have a couple of options on this type of thing. They can just ignore it and let the defense bring it up, or they can do what's called, they pull the sting. Right?
Draw the sting.
The sting. Yeah. Where they say, hey, on direct examination, we're going to tell you, jury, that this guy got caught with bad stuff, and we entered an agreement with him in order to testify, so that it's not like a surprise.
Not a gotcha. With the defense. And it's always the best practice. Yeah. If your witness has some skeletons in the closet, it's better for you to, as the party calling that witness, to bring that out so it doesn't look like you tried to pull the wool over the jury's eyes, right?
Yeah.
And so Flores' testimony, of course, becomes critical. Given the guilty verdict that occurred, obviously the jury at least believed something that he had to say.
Yeah, and so Devault, in her appeal of the case, brings that out and says, that was improper to allow him to talk about it. And they get kind of technical on how it happened in trial, that he kept being kind of gratuitously saying, and I documented it, even though it wasn't supposed to be mentioned that it was in writing, right? And he kept saying, and I documented it.
His notes.
Yeah, and then, it was mentioned again by another witness that there was documentation, when really that wasn't supposed to be part of it. And so she raised that, saying that was prejudicial, shouldn't have come out, and the court didn't buy that argument.
Yeah, and then the next issue that was developed by the in the appeal was kind of a battle of the experts issue. I don't think it merits a ton of discussion. Essentially, the state in the defense in the penalty phase had called their witness, talking about how Marissa suffered from PTSD and other conditions, which I guess contributed to the idea that she felt it necessary to defend herself in that moment against Dale. The state then calls an expert of their own to rebut that, saying, no, she actually has antisocial personality disorder traits, and not this idea of a battered woman. And they're free to do that, to rebut. Whenever you put someone's character in issue, the other side can call another witness, especially in the penalty phase of a case like this, to rebut that assertion or that opinion.
And I could be wrong. I think part of the decision by the Court of Appeals on this, though, was that the part that she was actually complaining about in the appeal was not part of the guilt phase. It was
penalty phase. That's what I'm talking about.
Yeah. And so, and because of that, they'd already decided, and I thought this was an interesting thing, they'd already decided that she was guilty, and the only thing that was on the table then was, are we going to give her death, or are we going to give her, life, right? And regardless of everything that happened, the jury came back with, we're not going to give her the death penalty. And so it couldn't have gone better, right? So it didn't have
got
any
what
negative,
she wanted.
Yeah, it didn't have any negative effect on that part of it.
Yeah. Now, the other issue that I think this is a little bit more of an interesting issue was prosecutorial misconduct. Now, that is a phrase that we have talked about many times. It comes up frequently in criminal cases on appeal. And of course, we've spent a lot of time talking about Juan Martinez and his antics and stuff like that. This defense team, or this prosecution team, according to the court, didn't commit any misconduct. What was alleged was that they had done what's called vouching for witnesses, meaning placing the credibility of the government behind the witness to try to bolster their believability as a witness. And Devault pointed to a number of instances where the prosecutor says, this witness testified truthfully, you can believe their testimony and so forth.
And Ms. Devault's a liar.
Right.
Yeah.
But that's not improper.
No.
What the evidence and the rules allow is any side, in closing arguments especially, can draw reasonable conclusions or argue reasonable conclusions based on the evidence that's presented.
And encourage the jury to make those inferences.
Right. What you can't do is, again, put the strength of the government behind it. Let me give you an example. That would be like saying, hey, I'm the prosecutor, and we called Joey as a witness. And we wouldn't, if we didn't believe Joey's testimony, in the first instance, we wouldn't have called him.
If he wasn't telling the truth, you think me as a righteous prosecutor would put this person on the stand? You can take it to the bank that we would never do that.
Me here in my white hat, I only put on truthful witnesses, right? You can't do that.
Can't do that.
Because now you're saying, hey, the government is here to, only tell the truth.
It's replacing the judgment of the jury.
That's right.
Right? And the credibility of a witness with the credibility of the government, right?
And so Devault's appellate counsel, kudos to them for arguing anything that they can, because that's what you should do.
You got to argue it.
But the truth is, it doesn't appear that there was any sort of vouching in that fashion.
Yeah, and it's interesting because, if anybody's been watching any of our work that we do here on these podcasts, they might think that we think every case has prosecutorial misconduct because we do focus on it on those cases where it seems to be important, right, or a big deal. And in some of those cases, those have been really strong arguments.
Yeah.
And so we're trying to be objective here. Hopefully you can see that and say, we have a case here where and usually we only say that if the Court of Appeals or somebody else also said that, but the Court of Appeals went through it in detail about why it wasn't vouching, why the things that they did was not misconduct, and those arguments just didn't have the facts behind them that the other ones did that we've talked about.
Agreed, and I think there's an important lesson here, and that lesson is the government can prosecute a case and do it correctly and get a guilty verdict without engaging in misconduct.
They already have so many advantages. Yeah. They already have so much in their favor. There is no reason for them to cheat and do things that violate people's rights in order to get the conviction.
And it takes us back to that ethical rule where prosecutors are required to be ministers of justice. Now they can fight hard, they can be passionate, they can use every advantage that they have to get their result that they believe is just. But you don't have to strike foul blows, as the court says. You can do things righteously and still get the result that you believe is justice. And to me, that's a really important lesson. Prosecutors are there to uphold and enforce the law, but they also have to follow the rules.
And I'd say for the most part, they do.
And I think
for the vast majority. Just sometimes you get these really high-profile cases where they really step out of bounds. And there's sometimes prosecutors that get lost a little bit in the idea that, even if the evidence doesn't quite get the jury there, I know they're guilty, and so whatever I do is justified in order to get that conviction.
And that sort of, result-oriented justice is it's difficult.
It's
right?
dangerous.
It's dangerous.
Yeah.
I think that's a far better word.
Yeah.
Anyway, so this prosecution team, I think they at least didn't break the rules according to the court.
And when I've seen, Mr. Dawson in trial, not that I've seen him a lot, very briefly, but talk about a different style than Juan Martinez as far as just laid back and reasonable. But then she makes another argument, which is interesting, of judicial bias.
This one's fun.
Saying that Judge Steinle didn't like her counsel and that prejudiced his decision making and the outcome of the trial.
Now, everyone is entitled to a fair trial, and they're also entitled to a fair judge. The judge's role is like an umpire in a baseball game. And the judge is there to call balls and strikes and to issue rulings. And they have to do so in a fair way. They don't necessarily have to be nice about it. They don't have to be kind in the way that they do it.
Sometimes they're not.
Sometimes they're not.
Yeah.
Let me give you one instance. So this one was funny.
This is a real window into Steinle, too.
Yeah, so I'll just read this from the opinion. The second incident involved the court's derogatory statements to defense counsel. While discussing a pattern of witnesses taking far longer than estimated, the court told defense counsel, quote, "You're never going to out-top me in the courtroom. So if you're going to get cute, I'm going to get cute right back." I mean, in my own limited interaction with Judge Steinle, that fits exactly right. I mean, he is just going to get in your face and tell it like it is. And that's what he did. And the court goes on to say, well, he did that to both sides.
He did that to the prosecutor, too.
He was pissed at the prosecutor just the same.
Which may tell you why it was a 16-day trial instead of a 67-day trial.
Yeah, and here the court goes on to say, more importantly, the court has authority to exercise reasonable control over trial proceedings. So the judge has to make everybody play by the rules, and they have to do so in a fair manner. Now, prior to going on the recording today, we talked a little bit about the difference perhaps between Judge Steinle and Judge Stevens in the Arias case. If Steinle had presided over Arias, do you think that Martinez would have gotten away with what he did?
No.
No way. Right?
I think, and we talked in that one about what would have been the right, remedy. Maybe his just style of how just being very real and being very, not being afraid to hurt people's feelings, that would have stopped it. And if not, I don't think he would have been afraid to, and not that I'm saying Judge Stevens did anything improper or should have done anything different, but maybe would have done the mistrial and said, if you're not going to do this right, we're going to do it again,
Yeah, if you're not going to do it right, we're going to do it again. I like how you said that, and I think that's exactly how he looks at it. He's very serious, and there's no question who's the boss in that courtroom.
As evidenced right there.
Right, you're not going to out-top me, counsel. Right, I'm going to get cute just the same.
Yeah, I saw him, we haven't done this case yet, the Dale Hausner.
Right, he was the judge
very
in that
famous case.
So that was a serial shooter case, and to our viewers, I'm sure we'll do that one in short order. That's a big Arizona case. So ultimately,
can I tell a funny story about judicial bias?
I'd love for it.
So when I was a prosecutor, I did a case against a very spirited defense attorney, and it was my very first jury trial.
All right.
Yeah, and she was
spirited,
wild.
Okay.
Yeah. So we had the judge get on the stand, and she goes, I'm going to notice this judge. He is biased against me, okay? And you can do that.
Yeah.
In Arizona, you have the right to basically strike one judge, right? So strikes the judge, and it's a little justice court, so they got to bring in another judge from somewhere else, and so we all sit around for an hour and a half, 2 hours. They get another judge there. New judge shows up, literally walks through the door, and she goes, "Oh no, you hate me."
Are you serious?
Yes. To the judge that walks in. I was like, this is wild.
Well, she's already burned her notice.
Exactly. So we start trial.
Yeah.
And every so often, she's got a photographer. Like, she has a photographer in court taking pictures. And every so often, she says, "Judge, I just want to put for the record the face that you're making at me right now.
Oh my goodness.
You obviously don't like me.
And this is in front of a jury.
In front of a jury.
What's the charge? Do you remember?
DUI.
All right.
Yeah. So fascinating, and just, it can certainly be done wrong on both sides. And, that was a real good lesson to me. If I ever become a defense attorney, mental note,
don't do that.
Don't burn every bridge in the courtroom.
The moment they walk in.
Every juror thought she was bananas.
Shoot.
Yeah.
Well, and if the judge did hate her, right? A couple things. I mean, you reminded the judge that
probably didn't even remember who you were.
Right.
Yeah.
But then, now you've set the stage for that judge to start off with that opinion. Why on earth would you do that?
I mean, I will say, I feel like it made him really, really cautious about every ruling.
Well, and maybe she's just, prepping the groundwork there.
For the appeal.
Can I ask you how it went?
Oh, it went well.
For the state?
No. Yes, for the state, for me.
Because you were a prosecutor back in the day.
Yeah. Well, and it was interesting because it stressed her client out so much that after the state put on our case and rested, the prosecutor just turns to me and just says, "Can I take a plea?" I mean, the defendant turns to me and says, "Can I just take a plea?"
Wow, you intimidated him, maybe his own lawyer. So back to Marissa Devault. She's convicted. She does, what's a couple of kind of closing interesting points. The jury is out for a long time, several days, 5 or 6 days of deliberation.
Yeah, you got like 16 days of trial and then 6 or 7 days of deliberation.
Emotional and sobbing. If you thought the courtroom moments we brought you last night were dramatic, then this latest round will really floor you. That was the scene. Elizabeth Irwin joins us now live. And Elizabeth, the jurors were actually dismissed early because Marissa Devault couldn't compose herself in the courtroom.
They were, Katie. Marissa Devault broke down in court when a photo of her husband was shown, showing his injuries after the alleged attack. We can't show you that photo because it's just too graphic, but we can show you the strange range of emotions Devault showed when she was being interrogated.
And he was snoring really loud.
Just hours after Marissa Devault is accused of beating her husband with a hammer so hard he later died, she's giggling. Jurors were shown this police interrogation video Wednesday in court.
I woke up to this. Okay.
In the video, Devault tells her first story, that she woke up to her husband choking her and screamed out for help.
And then the next thing I see is I saw a hammer go into Dale's head.
At that point, Devault claimed it was the couple's roommate who hit Dale Harrell with the hammer. It's clear the detective doing the questioning isn't buying it.
Marissa, this thing is not adding up.
Then a break from the video. The prosecution brings in the neurologist who tried to save Harrell's life. As he describes Harrell's injuries, Devault breaks down. The jurors are asked to leave, eventually sent home for the day. The judge getting angry, telling the lawyers this won't happen again.
This case is 5 years old.
And we're going to hear the rest of that interrogation.
So what does that tell you as a defense attorney? It tells me that they're struggling. They struggled with this one.
Yeah, generally that's what it tells us.
That's a good defense work right there. If you've got a jury out that long, you got them thinking. And it was probably, it's at points along the way, close to a mistrial, a hung jury.
Right, and that's what happens, right? If the jury can't come to a conclusion or to a decision, a unanimous decision, and then you give them more time and you keep instructing them and they can't do it, it's a mistrial. You got to do it all over again or else they let it go.
Yeah, and then there is, of course, the penalty phase. The state had alleged the death penalty in this case. We'd already mentioned it, but I'll say it again. The jury came back and was not able to reach a unanimous verdict as to the death, and so they award her, give her life, and then the judge chooses natural life. It's up to the judge to choose which version of life in Arizona. Is it life with parole after potentially 25 years or natural life? Judge Steinle imposes natural life, and so that's the sentence that she received.
Yeah, and that's interesting too because we've talked about the death penalty in Arizona as well. That they have to find certain. The jury doesn't know most of the time that after they give their guilty verdict, now you got to stick around for the next phase, now you got to make a decision on whether it's life or death. And they have to make a finding that it was, you know the wording, depraved or...
Cruel, heinous, depraved.
Cruel, heinous, depraved.
Yeah.
And they actually did make that finding, that it was, but then also made the decision that they didn't impose death.
Yeah, and I guess I should clarify what I said. There was a unanimous verdict, and that unanimous verdict was for a life sentence. And the type of life sentence is then up to the judge. So clearly, you know, the jury listened, and they, imposed the penalty that they believed to be appropriate. So, you know, that, in a nutshell, is Ms. Duvois' trial and the legal issues that were raised in that trial. Another fascinating Arizona case. We've dealt with 3 or 4 cases now of female murderers, right? This one with the hammer, Jodi with the knife and a gun. And then there was another gal that I forgot her name, murdered her husband who was dying of cancer. A number of these ladies in Arizona.
And I will say we're breaking a trend. The first ones that we did, I think it was like 4 out of 5 or 3 out of 4 had dismembered the bodies.
Right.
So
at least Winnie Ruth Judge, I forgot about her.
Yeah, so at least we're seeing now that they don't all do that.
Yeah, they don't all do that. Yeah. So. Anyway, another interesting case. Thank you for the discussion, Ryan. We'll see you next time.
Thank you.